the matter of the state of Rajasthan versus Surinder Singh Rathore, Supreme Court allowed the appeal and set aside the High Court judgment and held that the second FIR stands restored as it is much larger in scope than the previous FIR. The sole question for consideration of the court in this case was whether the registration of the subsequent FIR is legally permissible and whether the High Court was correct in exercising its inherent powers in questioning the same. The brief facts giving rise to the case are three persons, namely Vipin Parihar, Chief Marketing Officer, Fern Biofuel Private Limited, his business partner Deven Shah and Satyanarayan Saini, SD of Kusum Petrochemicals, lodged a complaint with the Anti-Corruption Bureau to the effect that the respondent, who is employed as Chief Executive Officer, cum Project Director Biofuel Authority, Government of Rajasthan, allegedly demanded a bribe at the rupees 2 per litre for the sale of biodiesel, that is rupees 15 lakhs per month, with a further rupees 5 lakhs for renewal of the license of the complainant. The FIR is numbered 123 of 2022 under Section 7 and 7A of the Prevention of Corruption Act. This demand took place on 4th April 2022. A second FIR was lodged on 14th April 2022 for the incidents which took place between 30th September 2021 and 12th April 2022 when Mr. Sham Prakash, constable with the Anti-Corruption Bureau, brought information to the notice of Mr. Parsamal, DSP, that amongst the other persons, the respondent is indulging in taking bribes to grant licenses to run biofuel pumps. One Nimbaram and Ashish were the middlemen who were put on surveillance after due permission from the competent authority. This FIR, running into nearly 30 pages, detailed the alleged conspiracy of which the respondents were a part and records in considerable detail the calls received and made by the various persons involved in furtherance of the object of conspiracy. The respondents, aggrieved by the registration of second FIR, preferred a petition under Section 482 Criminal Procedure Code 1973. It was held that the second FIR was an abuse of process of law by the High Court. On the aspect of prior permission being required to proceed against the respondent, it was found that the prior permission was a must, and without the same, the impugned FIR could not have been investigated. It was with this understanding that the High Court quashed the second FIR in exercise of the powers under Section 482 CRPC. While answering the question, Supreme Court referred to the judgment of T.T. Antony, which records the position that a second FIR is not maintainable and states that a case of fresh investigation based on the second or successive FIRs not being a counter case filed in connection with the same or connected cognizable offence alleged to have been committed in the course of same transaction and in respect of which, pursuant to FIR, either investigation is underway or final report under Section 173(2) has been forwarded to the magistrate, may be a fit case for exercise of power under Section 482 CRPC or under Articles 226 or 227 of the Constitution. This rule, however, over the years through judicial pronouncements has lent some flexibility. The court referred to the case of Anju Chaudhary versus State of UP, where this court dealt with the concept of a second FIR at length, which states it will thus be appropriate to follow the settled principle that there cannot be two FIRs registered for the same offence. However, when this incident is separate, offences are similar or different, or even where the subsequent crime is of such magnitude that it does not fall within the ambit and scope of FIR recorded first, then a second FIR could be registered. In the case of Nirmal Singh Kalom versus State of Punjab, Supreme Court held that in the following terms that when a new discovery is made, the second FIR would be maintainable. Discoveries may be made by the police authorities at a subsequent stage. Discovery about a larger conspiracy can also surface in another proceeding. As for example, in a case of this nature, if the police authorities did not make a fair investigation and left out conspiracy aspect of the matter from the purview of its investigation, in the opinion of the Supreme Court, as and when the same surfaced, it was open to the state or the High Court to direct investigation in respect of an offence which is distinct and separate from the one for which the FIR had already been launched. Thus, Supreme Court laid down principles for permissibility of second FIR. When the second FIR is counter-complaint or presents a rival version of a set of facts in reference to which an earlier FIR stands registered, when the ambit of the two FIRs is different, even though they may arise from the same set of circumstances, when investigation and or other avenues reveal the earlier FIR or set of facts to be part of larger conspiracy, when investigations and or persons related to the incident bring to the light hitherto unknown facts or circumstances, and where the incident is separate, offences are similar or different. Finally, court held that the quashing of the FIR would nip the investigation into such corruption in the bud. The same would be against the interest of the society. The second FIR pertains to the larger issue of widespread corruption in the concerned department and therefore is much larger in the scope than the previous FIR.